In Virginia, I think there's something like 15 different versions of reckless driving. All of them ultimately boil down to, were you driving in a way that showed a reckless disregard for your own safety or your own property or someone else's? So there's the general form, which is basically what I just said. Were you driving in a way that demonstrated a reckless disregard for life, limb, or property? And then there's a lot of more factually specific ones that the legislature has set out that are just sort of inherently reckless in their view, right? So passing a stopped school bus when the stop sign is out, driving at 80 miles per hour or more, regardless of what the speed limit is, or driving more than 20 miles per hour over the posted speed limit, regardless of what the speed limit is. Those are the two most common, the reckless driving general and the reckless driving by speed that defense attorneys see in Northern Virginia. There are also, driving with inadequate brakes, driving faster or more erratically than weather conditions permit, driving, trying to pass people in two-lane roads at a reckless speed or in a reckless manner, all sorts of things. There's even an offense called aggressive driving, which is basically road rage. Sometimes we see that instead of reckless driving. But a lot of these, particularly in Prince William, can be reduced down to a non-criminal traffic infraction, or sometimes dropped or dismissed entirely if the defendant is willing to take a driver improvement class to show sort of that they're trying to rehabilitate whatever driving behavior caused the case to begin with. So there are a lot of Virginia providers of the course. Prince William's pretty much accepts anywhere that the Virginia DMV holds as accredited. And so you can do those courses online, you can take them in person. It's 8 hours either way. There's a test at the end, which is probably 20 or 30 minutes. At the end of the course, another nice thing is that you get positive 5 points added to your point balance with Virginia DMV. But if you take the course as part of a court order or a plea, you get 0 points for it. It's sort of a pick your poison or pick your benefit from this course. So a lot of people take the course to get their case mitigated, and that in turn also heavily depends on what is the starting point of your driving record. If your driving record is bad, then the course might not save you or might not do as much for you. If your driving record is really good, you might not even need the course. If it's in between, the course is probably a smart move. And for DUIs, the course is not as important because the issue is sort of alcohol, not how do you drive when you're not under the influence. There are other drugs that can cause a DUI case too. Marijuana is a common one. Some people are on prescriptions that they shouldn't be driving on, or sleeping pills, over-the-counter stuff. The important thing to remember with the DUI, ultimately for your defense, there are levels that everyone talks about, 0.08, 0.15, 0.20. Those are presumptions that the legislature has enacted, saying if you are at this level, we are going to presume that you're impaired so much that you can't drive safely. But constitutionally and under the statute, the DUI statutes, you can rebut that presumption if you have enough evidence, how you performed on the field tests, getting into specifics about your tolerance for alcohol or other drugs, maybe your physical characteristics, your height, weight, all that stuff. You can prove that you were actually driving safely even if you had something in your system. So the case isn't just automatically over because there's a number next to your alcohol reading or whatever. Lots of people refuse the tests in order to determine how impaired you are. So many DUI cases start out with not only a DUI charge, but a refusal charge tacked onto it. Those are not criminal charges the first time, but they have severe civil consequences. And then if you get a second or subsequent offense, they become criminal charges as well.